All rise. You may be seated. All right, good morning. I am Judge Boatwright. I know that we have a school group in from QI Roberts. I think we have most of the mock trial team. Go ahead and, go ahead and introduce our judges. To my right is Judge Brian Lambert, and to my left is Judge Adrian Soud. And we have one more case on the docket this morning, which is case number 2022-2707, Lowry versus Lowry. And is the appellant ready to proceed?
Yes.
Okay, come on forward, sir.
Thank you. May it please the court, I'm Bill Gressley from Jacksonville on behalf of Lisa Lowry, the appellant. And Judge Soud, I conferred this a minute ago with Brother Korn, and this is our first opportunity to have you on one of our panels. Glad to see you. Glad to see you. Your Honors, we have three issues. Two of them are...
Would you like any rebuttal time?
Oh, I'm sorry, of course. 5 minutes, please.
Okay, thank
At
you.
least that's my aspirational goal.
All right, yes, sir.
The first and the easiest one in terms of what the record shows and what the analysis is the final judgment at issue here, assigning $145,000 to my client when those funds were used for her support during the pendency of this case. And that was unrebutted. The answer brief tries to claim, well, there wasn't enough evidence.
What was it used for? What support was it used for?
Everything she needed. The sort of twist about this beginning of this case is that the parties, after filing, still lived together for a while. And they had a joint account that both of them put their paychecks in and paid the monthly bills. And then
What about the $75,000 for your client, the tax bill?
she had to pay that out of this 145. That's part of what she used it for. When the husband stopped putting his check in the joint account and stopped paying the marital expenses from this account, she took half of, I can't remember the name of the account, but that was not a dispute. She took it, she used it for her support.
Was that a marital debt, or at that point, since it was at the time of filing, was she filing individually at that point?
Not that I'm aware of, Judge, but I do not know the answer to that specifically. And I apologize, I should. There's no question you can ask me that I should know the answer to, but I don't. I never saw anything suggesting that there was.
So what happened was, she testified, your client, Mrs. Lowry, testified that she still had $65,000 left at the time of the trial. You hear that?
I think that's correct.
I'm not sandbagging you. That's what she said.
Okay, I agree.
I mean, you weren't the trial lawyer, so I get all that.
But she also had still testified she still had a huge tax bill to pay. She'd already paid one, and she had a new one coming up. She works through her own PA for a company that provides ER services to Baptist hospitals.
So in essence, what you're saying here is there's an $80,000 that she used from the $145,000 she withdrew, which was half of the Vanguard brokerage account. And that $80,000 was improperly distributed to her in the trial court's equitable distribution plan.
That's correct.
That's your argument?
Yes.
Okay, but let me ask though, your client's exhibit number 11, admitted into evidence, where she said to the judge, here is my equitable distribution plan, I should receive that $145,000 and the husband should receive $141,111.46, which your client's attorney doubles down during the closing argument and explains to the trial judge, this is how I get to that, why she gets 145 and he gets 141. And you're here today on your first argument saying we should reverse a trial judge for doing pretty much exactly what your client requested that she do. How is that not invited error and that you should move on to your next issue?
Well, and maybe it is, Judge.
Well, how is it not? I mean,
well,
I'm trying to think that.
Well, because
we have trial judges sit in the audience, so I sit here and say we're going to write an opinion saying, you know what, you really screwed this one up, Judge, because you did exactly what she asked you to do, and these geniuses on the 5th ECA says, oh, don't listen to them. just go ahead and I get what your argument is, your technical argument is.
But that's only one component of the equitable distribution. He didn't have to touch his money, his share of that account, and he only got allocated cash that was actual cash.
Yeah, but your argument today is it was wrong to do that. Maybe it skewed the numbers now on appeal, as you're arguing. But to say the error is made that you distributed a dissipated asset when there was no misconduct found, when the judge did exactly what it is that was in evidence, and that they argued to her right before she issued her oral ruling, that was then,
Well, and the essence of this argument, the judge, is that she had no choice but to use these funds during the pendency of this case.
I get you.
And
If you had no evidence, if there was not a documented minute evidence, and if you didn't make the argument to do exactly that, I would agree with you.
well, the judge found there was no dissipation. And
She didn't have a reason to. She did exactly what your client asked him to do. That's her to do, isn't it?
well,
Good. I don't want to use all your time. I know you want to talk about element and stuff like that, but that seems to be problematic. If it makes you feel any better, I'm not sure why that your client was moved out of the house either, but that's probably something I should talk with Mr. Korn about more in depth.
The equitable distribution has several other components to it that need to be revisited. And one of them is that when the judge did the analysis for alimony and equitable distribution about the disparity in the parties' incomes, one of the things that she did, the judge, was used one aberrant year for my client of $266,000. And
She made a lot of money during the COVID because she was in
she was one of the few people who profited from COVID because
She had to work a lot because she was an ER physician that was needed.
That's exactly right. On page 11 of my reply brief, I've listed out the record sites for all of the income of the parties from 2019 through 2021. My client testified without contradiction that 1 year, 2020, was aberrant. $50,000.
Can I ask you this too here, and I will again preface, I know you were not the trial attorney. You talk about, this is a long-term marriage of which permanent alimony would, typically be on the table. That's actually not what was argued by your client's lawyer below. It was, you ought to give us 4 years of alimony, which I don't know that the lawyer called it that. I guess that'd be bridge the gap alimony. That's a different analysis than what you're kind of asking us to make. And so it becomes problematic to say, again, trial judge errors by not awarding permanent alimony that wasn't asked below.
Well, and I wasn't suggesting the permanent alimony. What she wanted, and this is the exclusive use and possession issue is a hybrid. It's a part of support. It usually is connected with some kind of spousal support as well as a non-economic component of child support. It's not on the guidelines worksheet. We have another issue about that in this case as well. But before you look at what the disparity in the parties' incomes are, I draw the court's attention to record 252, which is one of my clients' exhibit 2. It's a 216 through 220 analysis of the disparity in the parties' incomes. And for those 4 years, the husband's income was a total of $462,000 more than my client's. This court in the Vitalis case pointed out that an alimony analysis, whether you call it durational or short-term or whatever you want to call it, my client asked for 4 years of assistance so she could stay in the house until the youngest child was out of high school. And she wanted assistance with the mortgage and the monthly bills. She was given $3,000 a month in temporary support. The magistrate recognized that she was expending all of her money just to pay the bills for the house. And once the temporary order was entered, she was responsible for all of that. And that ultimately is going to benefit the husband as well, because at the time of the sale, the house is going to be intact. She'll get a
Let me ask, does this hurt your argument if you're saying she needed the money to be able to stay in the house with the kids? Part of the husband's argument is like, we got $800,000 equity in this house. We can sell it, have our own new house here, and we're good to go. And if on one hand, he makes a lot of money, you're fine. Relatively speaking, you're not pro athletes or something like that, but they both make a good bit of money. it seems to be the dichotomy of the scenario trial judges face in family law, saying there's just not enough money to keep the house anymore. These two clients are, I wouldn't say awash in money, but they certainly are better than most of the ones that the trial judges see in family law.
Absolutely.
Where you have the same income, but now you're going to have dual expenses, and what do we do? And they put the trial judges in a difficult bind, and then we look at them from up high in Mount Daytona, and
I'm sorry.
pretty funny.
No, it's a good question. The problem, not the problem, my client's perspective, and it's one of the issues we've raised, is that the exclusive use and possession was for the benefit of their children not having to be uprooted in the middle of the doors. And they had the money to do this. But
Case law says that, doesn't it?
I'm sorry?
Case law says that.
Yeah.
There has to be special circumstances not to do that.
Exactly.
In fact, the case law that your opponent cites in his answer brief says that.
May I ask a clarifying question? I want to make sure I heard you correctly. So, the former wife did not make the request below of exclusive use and possession or 4 years alimony. It was both, was it not?
She wanted exclusive use and possession and help from the husband to pay the mortgage.
That remains her position today.
That's correct.
Okay.
That's what we were asking for. Now,
Is she unable to pay the mortgage?
she is, that's how she's utilized a big chunk of her. You said it was 80,000. It's the 145,000 that she removed from.
So would that fall into the special circumstances as a compelling financial reason to partition the house at that point if she's unable to make that payment?
They had this house together. He has lots of cash assets and has lots of options. And that was the reason she asked for some assistance from them, was so she could continue to stay in that house. And she couldn't do it herself because she, as the magistrate recognized, she was depleting all of her income just to pay the house.
So are you saying if we reverse then, if we reverse that, then we would have to order some type of alimony so she could stay in the house, otherwise she wouldn't be able to?
I think that the analysis is what Judge Lambert wrote in the Holland case, which I've talked about in the brief, cited to, which is the aberrant income year here for my client was $50,000 more than she ever made. And I'm using gross figures, rounded figures. That is not her actual income. The former husband's temporary support was based on 60% of what he actually made. So what we have here is no alimony analysis because he says, the judge says she doesn't need it. Sell the house and everybody goes away. But I think that the real question here is, and this is a unique issue, and it's the converse side of the Wright decision, which I cited in my brief, which is these parties, both of them, to their credit, said our obligation to our children does not stop when they age out. It's not a statutory analysis. These are still our kids, both of them. And I've got the cites for the trial financial affidavits if the court wants them. But they both list some of the money that they have as expenses helping their college-age children. And the issue about the horses has gotten really distorted. It doesn't matter, in my position on this is that my client and the husband agreed that these were a great thing for their children and they wanted them to continue. It's like the court can't order a party to send their children to private school, but if they agree...
Are you still arguing that you want to keep 4 horses?
The 2 of them are paying for themselves, and I'm assuming that she's going to sell them at some point because as children get older and they need different horses.
That's kind of a hard argument when you're complaining about money and then you say you got 4 horses, correct?
Yes, except to the actual testimony, which was unrebutted. There's 2 important parts. One is the husband admitted he knew nothing about the expenses of these horses. Secondly, the wife testified that the 2 horses that were being complained about were being leased out and used for riding purposes and paying for themselves. The husband said, I'm glad for my girls to keep riding horses. It's been really good for them and I'm glad to pay for it. And without any factual basis whatsoever, the trial court said, okay, you pay $875 a month, when the evidence was uncontradicted that the cost was about $4,000 a month. Yes, this is a problem for people with assets. But it is my position that once the parties have agreed that this is something that is part of the marital lifestyle, that becomes a proper consideration for an alimony analysis. Now, in the Wright case, if I'm not mistaken, were you on the other side of the Wright case, Michael? Yeah, both.
1 and 2.
1 and 2.
We'll talk about that.
Yeah, the Wright case, my client was the appellant who argued there's all these expenses for our children's extracurricular activities that should have been granted. Well, the husband fought against that. He objected. He said, I'm not paying for that. And this court said, if you want extra money for the children's extracurricular activities, you have to go through the guidelines which allow 5% deviation with fact findings. That's not this case. This was not disputed. What was disputed was the amount.
Okay, you got the voice. But let's step back and let me be real clear about this. All right, we have case law that says absent compelling financial reasons, the custodial parent should be awarded exclusive use and possession of the marital residence until the children reach majority or become emancipated, basically. And all right, so absent compelling circumstances. I want to make sure that I read your brief differently than what I think I'm hearing today, and you better. This is your chance to finalize it, I guess. Are you saying that if we affirm the trial court's denial of alimony, that your client now has compelling financial reasons to have the marital home sold in partition as the trial judge ordered? Or are you saying that whether we affirm or not affirm the alimony award, or if we affirm the alimony award, she still wants exclusive use and possession of the home for the kids because she's able to maintain it for the next 2 years until the youngest one's of age?
She can't maintain it without help from him. We're interrelated.
Okie dokie, man.
Well, let's look at the Holland case, Judge. I think you wrote the opinion in that one.
Yeah.
Recognizing that COVID is a financial issue that on remand, courts should take current circumstances, because what this did to my client was devastated her financially, is that she wasn't going to move the children out, and when the judge denied any exclusive use and possession to her, and she still got to pay for all the bills until it gets sold, she has paid a price for that. And the judge used a 1 aberrant year of income to compare their incomes and do the alimony analysis, which is just not correct. And finally, I'd like to direct the court's attention to record 609 through 614.
So I don't want to stop you. You're in the middle of your rebuttal. You can.
I am. I just wanted to see, the husband spends $30,000 a year on his golf and accessories, and that's an ongoing expense, and she says he doesn't have the ability to pay, and she doesn't need it. I'll let you use the rest of my time for rebuttal.
Good morning, Your Honors, and please the court. Michael Korn of Jacksonville. I represent the appellee, Mark Lowry. None of the issues that have been raised by the wife in this case trigger any type of harmful or reversible error standard. I do want to address.
It sounded like the exclusive use and possession one
I would like to,
had at least facially some discussable issues that I'm not sure
yes, sir.
has not inured to your benefit as we talk.
I understood the court's questions to opposing counsel, so let me start there.
You think you need to? Go ahead.
I think at least to address one of your questions and also Judge Boatwright's observation about special circumstances. How the special circumstances were addressed below dealt with the situation where the husband was still on the mortgage of this home that was worth in excess of $1.3 million. He testified that he could not obtain his own home because he was still on the mortgage. In fact, ironically, he was the one who sought the temporary order. Before the temporary order
Did
was
he produce any evidence at the trial that he actually couldn't get a mortgage, or was he just stating that more of his opinion?
That was his testimony, Your Honor. One of the things that counsel
I know they
below,
raised that in their brief.
That we should
This
have-
is more conjecture that you needed to have somebody from a mortgage company or from the bank there. I mean, is that a legal requirement?
no, sir, and certainly the husband's testimony as to that issue we submit is ample, competent, substantial evidence to support that. There was no requirement for the husband to bring in a loan officer or an actuary or anything of that nature. But the special circumstance that relates to the husband still being on the note and mortgage was he was unable to live anywhere other than in a small 2-bedroom apartment, which materially impacted his ability to exercise overnight time sharing with the 2 minor daughters.
Which I found to be baffling here. So, I mean, his argument was, we need to sell the house, the home that the kids are living in with the mother, who has the most of the majority of the time sharing. We need to sell the house because the kids are not as comfortable living or visiting with me or time sharing with me in my small apartment because that's not what they're used to. He's got close to $250,000 cash assets. He's making $250 to $300. It didn't dawn on the trial judge to say, well, maybe you ought to move into a bigger apartment or a bigger house so the kids can have their own room. It was, oh, no. We got to kick them out of the house and sell the house.
Well, you know,
I mean, how is that not the grossest abuse of discretion that may have been unwound today in your benefit, but still, that was certainly problematic to me coming into that.
Respectfully, I would submit that the testimony that the husband presented at trial was he had examined homes in the Nocatee neighborhood, homes that would not have disrupted the 2 daughters from either their childhood friends, or their educational catchment area for their school. And that if the unlocked equity in the home, which was approximately $800,000, was distributed per sale, each party could get a home that would be more than sufficient. This home, Your Honor, 5 bedrooms, 4 bathrooms, over 4,000 square feet, extensive mortgage, extensive repair and maintenance costs, which were regular. The home now is occupied by the wife, 1 minor daughter. The other 3 children are all aged out. The third daughter, the oldest of the 2 daughters, reached age majority while this appeal was pending in the middle of 2023. So you've got, yes, is it a house that the children had lived in before? True. Do circumstances change during people's lives? Yes. And we believe that it was not an abuse of discretion for the trial court to say, look, let's unlock this equity. Let's get her into a house that's suitable, but not 5 bedrooms.
So his basis for not being able to afford another house, was it the mortgage or was it just his income?
Ability to qualify, that was what he testified to.
Okay, because did I read correctly that he has $6,000 of surplus each month?
No, no, sir. After after all was said and done, and again, counsel talked about COVID. COVID works both ways. In this case, it worked to the husband's detriment. We'll talk about that in a moment. My recollection of what the actual record evidence showed was that his surplus was in the $2,000 to $3,000 range monthly after all was said and done.
I mean, the case you cite for there was no abuse of discretion was the opinion Judge Evanderode and Korestein. Dramatically different financial circumstances where we found no abuse of discretion. The wife had not become self-supporting during the 4 years of separation, had no money left, $100,000 in debt, and they were actually borrowing money from her family members to pay the property taxes on the marital home. None of which is remotely close to what happened in this case. Here, now, we heard today that if we affirm the denial of alimony, she can't afford the home. That may then have walked your way into compelling circumstances that justify finding a no abuse of discretion.
Understood. Understood. But
You probably want to walk to the next issue.
I'm fixing to right now. Your Honor.
I think we beat the dead horse.
Yeah, well, we got at least
physically here.
Yeah, we have
I'm
more
from
than.
Ocala, too.
Yes, sir. Well, we have more than one horse to kick, I guess, at this point.
Well, I still see signs of life in the 1 horse on the house, so I want you to answer his question, and I'm going to have a couple questions.
Okay. Is the case law different than the case that Judge Evander wrote? Yes. But I would
Your
submit.
facts are dramatically different.
Well, that's fine.
Yeah, I mean, your case law's different.
Why I answered it the way I did, I'm
Yeah.
sorry. But in this instance, we submit that it was just not an abuse of that discretion. Could reasonable people differ as to whether it might be better for the now 1 child and mom to live in the 4,000 square foot house? They might differ, but that doesn't trigger the standard test of an abuse of discretion.
I mean, I
People
understand.
could not differ.
Well, I mean, he walks out of the marriage, you know, with the finance. He has no alimony obligation, and as we talk here, as you point out, one of the children has aged up during the course of the appeal, which, per their agreement approved by the trial court, reduced his child support obligation by another $1,200 or $1,300 a month. So he's financially in a better scenario here than he was when he was looking down the barrel at the time of the divorce.
Well,
Tell me why he's not. I mean,
Well,
unless something outside the record has happened. Yep, he lost all his clients or something like that.
right. Well, I can't go. I
Right.
can't and
I'm
wouldn't
not
go
asking-
outside of
I'm
the
not
record.
asking you to do that.
But one point that counsel made, and it addresses the House, and then with Judge South's permission, we'll move to something else. But he said, look, you know, this only benefits the husband. He omits the fact that the order specifically gives the wife a credit for any mortgage payments that she made post judgment. So it's not like, you know, that there's some kind of improper gain being made. She'll get credit for that.
I'm not saying she's getting improper gain or she's losing. She gets credit, understandably. She's paying her mortgage, and he's ignoring the equities building because of her benefit of post-divorce payments. But I mean, she's still saying, I want to stay in the home, even if it's turned into a lot bigger home vis-a-vis the amount of people still in there. It's still the home the kids lived in. And, you know, there's all kinds of case law maybe that's outdated and nowadays that talks about how important it is not to do that to kids in the coming out of the marriage, because they shouldn't be the ones that suffer. It seems like they are suffering here by this.
And may I piggyback exactly on his question, if you don't mind, Judge Lambert? That's exactly what I was trying to look at. I understand that there's competent, substantial evidence to an extent. Your argument, his testimony, is competent, substantial evidence as to what he can and cannot afford, or what he can and cannot qualify for. I had noted, and it's somewhat interesting to me, that, and the judge has to take all of the testimony and all of the evidence in making the determination, and that's our evaluation on abuse of discretion. And what he can or cannot afford or qualify for, I think, let's talk about qualification. That remains to be seen, but it's difficult. I think Judge Lambert and Judge Boatwright both rightly referenced the law that absent compelling circumstances, the presumption is the children stay in the home, and I think we all understand that's because in a divorce posture, as it pertains to the residents, the eyes of the law are on the children. Typically, in this particular question and analysis. And how is it we're supposed to, in evaluating abuse of discretion, close our eyes to, frankly, what Mr. Grassley referenced, golf expenses, $2,185 in January of 2020. Yes, it's pre-COVID, I understand that. $5,514 in February 2020. And it goes on into other months, and not all are that high, and I recognize that. But ultimately, my viewpoint is the wife has not asked for permanent alimony in a long-term marriage, presumably considering needability analysis. She has asked for alimony. That decision was made on a 4-year term. She has asked for the exclusive use of possession of that residence for the benefit of now 1, but at the time 2 of the minor children who were there. Why should the court feel warranted in discounting other aspects of the evidence and simply saying the husband can't qualify for a second mortgage and his proposal of other like homes is sufficient? Because I don't think it's the like home the law is worried about. It's the impact upon the child of being pulled out of her house that the law is worried about in the midst of an already difficult environment. So why is it not an abuse of discretion for the judge to not consider those other factors as it pertains to the marital residence?
Well, I don't think that we can say from this record that the court did not consider that. But I think, Your Honor talked about impact, and that was precisely the point of what the husband's testimony went to. This is not a situation where the then 2 daughters would be taken from the 5,000 square foot home into a garden apartment. They would be able to have a home in the same neighborhood. They would be able to maintain similar relationships with existing friends. And yes, impact of any divorce has an impact. Of course it does. But this was a manner to minimize the impact not necessarily to the detriment of the children. I mean, mom says that the horses were keeping these children alive. Well, one would argue, well, if she still got the horses, does she get the horses and the house and everything else? To your question about golf, let me just address that really quickly. He testified again without contradiction. It was just an integral part of his business development. He used it extensively. He talked about TPC Sawgrass. Your Honor will recall that testimony. That's the spend money to make money type of analysis. Those were business expenses. Whether you call that part of his lifestyle, it was what generated food on the table. And so respectfully, I think that the golf is kind of a red herring here, because it's just as if somebody decided that they wanted to entertain by taking somebody on a ski trip, or buying tickets to the ball game. Or
There's
whatever.
a business purpose.
Absolutely. That was unrebutted. So I understand the court's questioning about whether special circumstances exist. We would submit that they do. I will like to move on, I think, to the need issue. I know that was a subject of question. Counsel raised Wright. I don't think Wright was ever cited in the briefs. Wright 1 dealt with the sole issue of whether, when a trial court makes a determination of whether the requesting spouse has a need, whether you have to then go on and do all of the additional analysis of the factors of 61.08. That was what Wright 1 was about. And because in that case, the court simply said, I find that the requesting party, in that case the wife, had no need, we don't have to do the 61.08 factors. In this case, the court made extensive findings about each of the relevant 61.08 factors. So Wright's irrelevant, and Wright 2 is PCA in favor of the husband, as it turned out at the end of the day. That's why when he said, what was I involved in? Yes, both Wright 1 and Wright 2. So that's a red herring for us. Here, the court went through each of the expenses. Counsel talked about the obligations of parents for college. In a perfect world, we would pay for college. I still pay for my daughter's cell phone bill. She's on my plan. Okay? So, yeah, there are things that parents do for their children, and in a perfect world, they continue to do it forever. But the law says we can't compel a parent to pay college expenses post age majority. And whether that's a good or a bad reason, take it up with the legislature. That's not what we can do. There's no agreement here. There was I would say, a course of dealing, maybe is the better approach. What I mean by that is, yeah, there were expenses paid for the 2 elder sons. There were certainly, I suppose, contemplated expenses for the 2 girls. In fact, the 3rd girl, Abby, who has aged out of majority, was even the subject of, well, she's going to probably not be riding horses much if she's off to college. So, some of these factors do kind of play with each other. When we come back to need, ultimately, that is the analysis that the trial court did. They looked at the income that the wife was making, whether or not she resumes the type of practice that she had during COVID. Hard to say. The husband's expert specifically said if she added 1 more shift at the emergency room a week, she could add about $102,000 gross annually to her income. Now, that's not what we have here necessarily, and the court did not make express imputation finding. This wasn't an imputation case. The point is, the court was able to analyze if you backed out the college expenses, if you backed out the horse, which he is paying for, and I don't want to spend a lot of time on that, frankly. It is a sideshow, but ironically, it became the communication barrier with these parties that helped, frankly, break this marriage up.
The purchase of the 2 additional horses.
Well, that was kind of
That was
the
a
coup de grace.
demonstration.
Yeah, in the middle of COVID, when all of his clients are shutting down and he can't travel, and she buys another horse. And she continues to rent the beach house in South Carolina.
So that was the straw that broke the camel's back, or the horse's back?
It may have been or let the horse get out of the barn. I'm not sure which analogy, Judge, we want to use. But in this instance, the court backed out those expenses. He's paying the reason, and counsel says that he had no idea about the horses. That's not true. He specifically said, I don't know it to the penny, but I know that they board him, I know that they take lessons, I know this, and I know that. And the number that they came up with was based on his estimate of what was being expensed for 4 horses. Judge says, okay, if I'm gonna do this as an element of child support, you know, she can do her deal with Happy and Salty, but the other two, well, he'll pay half of it, up to half, and capped it at the number which was half. And why was that important? Is because it eliminated the possibility that, you know, the wife or the child said, geez, I'd like to have a $10,000 saddle. Dad, pay for the 5. So what? And that was the post-judgment motion practice, which clarified that the horse expense was up to 1/2, up to the cap of $875, except if there was an extraordinary medical emergency, the vet, you know, it was a vet bill, something like that, then he paid for it. Why is all of that significant? Because it goes back to the fact that she did not establish need. And the court made an express finding in the judgment that after we take out the $1,000 a month for gifts, and we take out the horses, and we take out the college, and we take out some of these other things that she wasn't using, she can meet her own needs, even based on her existing emergency room work and the telemedicine work that she does, often from the
So
horse
even
farm.
if your client has the financial ability to pay, it doesn't matter because the first prong, the need, was not met according to the trial judge, and you're saying that's based on competent evidence, so there's no abuse of discretion.
Absolutely, and of course, the case law is legion. We cited in our brief, Judge Lambert, that disparity in income is not a justification if there is no need. That's pretty.
We don't equalize the incomes after.
That's
the fact.
right. That's right.
If
And
one makes 10 million and one makes 5, we don't say you owe 2.5, so it comes out at 7.5.
the question is that under your hypothetical, the spouse with the 5 has ample resources to be able to live and to enjoy life, and not at some reduced level as the wife seemed to suggest that he was paying all the expenses before the temp needs order, which he asked for. And the reason he wanted that temp needs order was that was the basis to trigger, so he could see if he could start reducing on the
If the
expenses.
trial court had allowed her, had not ordered the partition, would that have changed that analysis, though? That's sure need.
I'm sorry, if the court had
If the
not.
trial court had not, had ordered, if the trial court had not ordered the partition of the house, from the appellant's argument is, she has a need, apparently a need for money to make the house payment. So would that have changed that alimony analysis?
I don't believe so, Your Honor, because she worked through all the expenses. And the other thing too, although, you know, there's kind of that dividing line between child support and alimony here, he was paying over $3,100 a month in excess of what guidelines said, because he was not taking any of the deduction that he would otherwise been entitled to because of the timeshare.
Or it's 40%.
Well,
Or it's 40%.
correct, for his 40% timeshare, that's right. Plus the horses as an additional add-on to the expense.
Let me ask this, does the record evidence support that the wife can pay the house payment even without an alimony award?
I believe it does, Your Honor.
Okay.
Thank you. My time has expired. I appreciate the court's vigorous questioning, and I thank the court for your consideration.
Judge Lambert, in answer to your last question.
To him? Or
I'm
to you?
sorry.
My last question to you or to Mr. Corn?
Well, let me,
Probably should have liked his last answer. Go ahead.
but she does have a need. And that goes to this thing about unwinding my argument. I think you and I have not communicated. What she asked for was exclusive use and possession and some support from him so she could afford it better than she can now. The magistrate found, and nothing contradicts it, that she was having to spend all of her money from her paycheck with no assistance from the husband to meet the expenses. Am I saying that she...
So that goes back to the question I think we've asked you before, is she able to pay for the house without additional alimony? And you had said before, no.
Well,
Is that
she
answer
can pay
changing?
it, but she has limited ability. And the last question you asked, Mr. Corn, I want to make sure that there's not a misunderstanding.
I understood him fine. I hope you understand what he said.
I do.
Okay.
The way he said that the husband's paying $3,100 more than guidelines, he's paying $3,100. I just want to make sure that's clear.
Here, the exclusive use of possession, I mean, obviously we've talked about, because that, as Judge Saud aptly points out, a child's affected by that ruling here.
Yes.
And the law should look out for the children, because they're not the ones who asked for this. And so the case law that has come out of our court basically says you should get exclusive use and possession unless there are special circumstances or compelling financial reasons not to do that. The Korestein case that Judge Evander wrote 10 or 11 years ago, there were dire financial circumstances, so it made perfect sense, or it certainly was not an abuse of discretion for the trial judge to say, I got nothing, that's all I can do to help your family financially.
Right.
Here's that's not bad
No,
at
it's
all.
not. It's
And
not.
the argument, it seems, would be, regardless of alimony or not, I know you want to get the alimony award that reverse that. Regardless, is the exclusive use and possession is separate. Your client does make considerable money.
Yes.
And she is not in dire financial, she would be in better financial circumstances if, it's like any of us. If I made $50,000 a year more, I'd be better off than I am now.
Right.
Okay, but that's not the issue.
But I want to make sure you understand, I'm not saying that
But when
Don't
you
award
when you
alimony.
keep telling us that she can't keep the house unless she gets alimony.
that's not what I'm telling you.
Okay.
What I'm saying is she's expending her whole paycheck to stay in the house. That was,
So she's not in a dire financial state like Miss Korestein
No.
was, where she was $100,000 in debt.
And part of this that needs to be kept in mind is that each party has listed several $1,000s a month in helping their adult children. And so when you ask if the husband has a surplus, Mr. Korn is correct that shows on his financial affidavit that he has $2,000 some odd a month surplus. You take away the $2,000 or $3,000 he's paying for his adult children, and he has a much greater surplus. So there was a need. He does have the ability to pay, and he's the one who picked the tiny apartment. No one else did. He had plenty of money to go find someplace better. Thank you, Your Honor.
Thank you. Thank you, gentlemen. Very well argued case.